This was a problem that in order to see the pattern of cancer or make any kind of connections, the view was always, bird's eye view was always 30,000 foot level. It was the view of the epidemiologist to see is there a pattern of disease in the community and can we relate that pattern in time to contamination in the wells. The problem for the law was the law is very comfortable on the individual level, making, if you can fill in those factual elements, but really poor on, the kind of looking at it on gross or looking at it from an epidemiologic level. Now, there was some push in the law at that time to say, look, we can't really prove these cases on a personal level, but we got to, we are seeing patterns, or we might, scientists are telling us that there could be these patterns of disease that are related to a certain event. So shouldn't the law recognize that and allow for a lawsuit to be built over around the concept that people could be held responsible if you could show there is a pattern of disease connected to that? But here we were faced with an environmental problem that the law really had never been confronted with. This was a new whole area of thinking. Love Canal was, new to everybody's consciousness. This was only a few years after Love Canal. Now we had a blight of cancer, contaminated wells, industrial chemicals in the wells, solvents who are in a family, a bad family, known, to have certain toxic effects, but little else to make these connections. So, faced with that, the choice that we made, if we were going to help them as a lawyer, is that we decided that if we were going to be able to prove this case, we had to do it from both sides. We had to both look at it at the epidemiologic level, and we also had to look at it at the personal level, the clinical level. We had to combine both approaches. And the way we got there was we were forced in our thinking to go to individuals. So we would go to an epidemiologist. We would go to a geologist, a hydrogeologist, a toxicologist, and they would all send us to other disciplines because, well, I could do this, but I can't do that. And then we had all these different ologists who could look at different pieces, but nobody who could see the whole thing. So basically, we were the ones forcing a whole picture. And in order to that, we had to actually bring them together. We had to bring them to a place like this. In fact, we did meet here many times, and in other university settings and hotels and conference rooms all around the country, where we would gather our different experts together to do work together and to share their knowledge from their different perspectives and to begin to come up with a common language, because nobody at that time had ever asked all those different disciplines to look at the problem to see if they could see connections or patterns. Now, we were driven from a lawsuit perspective, as I needed answers, hard factual answers for me to be able to prosecute this claim. And then we were forced during the progress of that lawsuit to actually come up with the factual evidence. We had to do original scientific, our team had to do original scientific and medical work in order to answer questions that we needed to prosecute the lawsuit. So in the pressure cooker of litigation, we were doing original scientific, our team was doing original scientific research, which I do not recommend for any aspiring lawyer or any other person who wishes to maintain some hold on their sanity.